welcome to Scones Law. It's me, Sadamotu, and today we are going to be talking about damages under negligence in tort law. But before we proceed, if you have not subscribed, please subscribe. If you have, please turn on the notifications button so that when we post new videos, you know. Also comment so that we know what you think about our videos, and also let us know what areas of law you would like us to do videos on. In our very first video on tort law, we started by discussing negligence. We discussed duty of care. We've talked about breach of that duty, and we've learned that the third leg or the third element needed to be established if you want to be successful in an action for negligence is damages. Now, in establishing damages, there are two things you need to show. First, you need to show causation, and then second, you need to show remoteness. Causation being that the defendant's action caused your injury. Remoteness being that the injury you suffered was not remote, or it wasn't too far from the defendant's action or from the defendant's tort. To establish causation, you need to be able to show that but for the defendant's act or but for the defendant's tort, you would not have suffered the injury you suffered. This is illustrated in a case called Barnett versus Chelsea and Kensington Hospital, in which case a man was sick. He went to the hospital. He asked to see a doctor. The doctor looked at him and said that, well, it's not anything serious. He should go home and then see his general practitioner the next morning. 6 hours later, the man suffered arsenic poisoning and died. His estate sued the hospital and the doctor, claiming that they had been negligent and that had they attended to the man would not have died from his injuries. The question was, if the doctor had attended to the man, would he still have died? It was found that arsenic poison was such a strong, condition, and so even if the doctor had seen him, he was still going to die. The Batford test could not have been established, and so the action failed. Where there are multiple subsequent causes, i.e. causes that happened after each other but resulted in the same injury, you realize that the Batford test can be established with respect to the first cause, but not all the other causes that come after it. In Performance Cars versus Abraham, there were two actions. First, an action of a third party, someone else, not a party in the case, which resulted in injury to the plaintiff's car. He was able to obtain damages from that person in court, but before he could repair that injury or that damage to his car, another person, which is the defendant in this case, also did something which results in the same damage to his car. His action against the defendant failed because that injury was already there, so he wasn't able to establish that but for the defendant's action or but for the defendant's tort, his car would have suffered that injury, because you remember the injury is already there by someone else. Okay. But where the causes are concurrent, which means that you have 2 or 3 separate actions resulting in the same damage, in that case, you cannot establish the Batford test even against one of them. So the difficulty here is that you will not be able to establish that but for any of their actions, the injury would not have resulted to you, or that you will not have suffered the injury you did. The position under the common law is that you may show that on a balance of probabilities, one of those causes was more likely to have been the cause of your injury, or you may show that one of those causes, although not the cause of your injury, materially increased your risk to the injury, right? So in Bonington Castings versus Ward law, what the claimant showed was that there was a 50% chance that the defendant's actions was what caused his injury. So there were 2 possible causes. Okay, it's either the defendant's action or another thing. And he showed that once there was another thing, there were only 2 possible causes, then there was at least a 50% chance that the defendant's actions caused his injury, which was acceptable to the court, or which was accepted by the court, because the court thought that a 50% chance was enough to warrant liability, although damages may decrease to reflect that 50% probability. Another case that shows this is Wiltshire versus Essex Area Health Authority. In that case, there was only a 25% chance that a doctor's negligence was what caused a baby's injury. The court said that 25% was too small to hold the doctor liable. So even though we may be looking at probability, the higher the probability, the more likely the courts are likely to hold liability. Like I said, except that they would reduce damages to reflect the percentage or the probability. The second thing, like I said, which you can show, was found in McGee versus National Coal Board, in which case there were two causes. First, that because the employer failed to provide the employee, which was the claimant in this case, cleaning materials to wash off dust from the bricks he had been working with, he suffered dermatitis. Or there was a possibility that it was not necessarily about him not being given washing materials at the workplace, but rather the fact that he had to keep the dust on him till he got home to wash it off. So which of these two was the cause of his injury? The court said that the claimant in this case did not need to establish that his boss's failure to provide him with the washing materials or the washing equipment was what caused his injury. That he is able to show that the failure by his boss to have provided him with washing materials increased his risk to contracting dermatitis was enough. So you can either choose the Bonington Castings versus World Law position, which is that you are going by probability, or you choose the McGee versus National Coal Board test, which is that you are showing that the defendant's action materially increased your risk. The next thing after showing causation, like I mentioned earlier, is to show remoteness. In other words, you are establishing that the injury is not too far from the defendant's action so that the reasonable man could not have foreseen that such an injury will result. An important principle here is the principle that the law does not concern itself with trivialities. So if the injury is too far so that no reasonable man under the circumstances could have perceived it to flow from the defendant's action, it is unlikely that the court will hold that there has been damages. There may be breach of the duty, but because the injury was too remote, the court will hold that the damages requirement has not been met. In satisfying the remoteness bit of damages, we have two rules. We have the wagon mound rule, and then there is the re polemis rule. Under the re polemis rule, a person is liable for all the injury that results from his breach, regardless of whether or not it was foreseeable. So under the re polemis rule, if you owe a duty of care, if you breach that duty, and as a result of that breach, injury results, you will be held liable regardless of the fact that the injury that has resulted was quite unforeseeable. Under the wagon mound rule, which is a Privy Council decision in 1961, it was held that once the kind of injury was foreseeable, we need not foresee the particular type or the specific injury that could arise. But once the kind of injury was foreseeable, then the defendants will be liable. So in Bradford versus Robinson Rentals Limited, an employer sent their employee to go and check out a certain vehicle while it was snowing. Neither the vehicle the employee was sent in and the one he was sent to had a heating system or a heating mechanism. The employee ended up with a type of injury called frostbite. The employers were held liable because even though they could not have foreseen the specific type of injury, if they don't provide him with a heating system of some sort, they knew that it is possible for him to have contracted some sort of injury from staying out in the cold for too long. So they could not have foreseen frostbite, but they could have foreseen, or at least the reasonable man in their circumstances could have foreseen injury resulting from the excessive cold, right? So in this case, they were held liable because the kind of injury was foreseeable. In talking about damages, one principle you need to bear in mind is the eggshell skull rule, which is that you take your victim as you find him. In Smith versus Leach, a man had cancer. He already was predisposed to cancer. As a result of the negligence of another person, he suffered injury that resulted in cancer. The defendant's defense was that this man was already going to suffer the cancer anyway. So what is the guarantee that it was because of my actions that he ended up with cancer? The court said that you take your victim as you find him, so that his underlying health condition does not exonerate you from liability simply because of that health condition he was predisposed to the injury you exposed him to by your breach. This is where we end today's video. I'll see you again another time as we discuss other aspects of the law. Bye.